Okay, hi guys. So I'm taking a very brief interlude so I can go through Tag. Tag have filed actually a reply to Lively's opposition to their renewed motion for summary judgment. Now, I wanted to get to this because I think it's quite important because there were some questions and I was like, when I went through Lively's opposition, I thought, well, I didn't overly buy it at all. But I could see some of the arguments they were making. But I did say I wanted to see so I keep saying Wayfair. I want to see what tags say about it. And now we have our answer from the absolutely wonderful Kevin Fritz. So I'm expecting this to be good. All right. Okay. Defendant Tag respectfully submits this memorandum of law in response to plaintiff Blake Lively's opposition to Tag's motion for summary judgment on the seventh cause of action for aiding and abetting of retaliation in violation of FIHA. This motion addresses California's similar treatment of issues of direct liability and aiding and abetting liability. Lively improperly attacks Tag for engaging in the legal analysis that was prompted by the court in its recent opinion and order. She argues that Tag erroneously relies upon California case law pertaining to whether a business entity agent may be held directly liable for retaliation under FIHA, which is a claim she does not assert against Tag. Okay. Let's just move that up. However, as Lively knows, yet chooses to disregard in its recent opinion and order, the court noted that there is at least some reason to believe that aiding and abetting liability might apply to business entity agents, given that the California Supreme Court treated issues of direct liability and aiding and abetting liability similarly in Reno. Exactly. Right, so Lively's like critiquing, going, no, she's misquoting the law, she's got it wrong, blah blah blah. It was actually the court raised the question. Lyman raised the question actually that the argument that Tag's making in his order on the motion for summary judgment. So, yeah, Lively was wrong. The court then stated that the parties have not addressed this issue at any length. In accordance with the court's invitation, Tag's subsequent motion demonstrates why California's similar treatment of issues of direct liability and aiding and abetting liability warrants a finding that Tag cannot be held liable under FIHA. A predicate for direct liability is the defendant's engagement in FIHA-regulated activities, and Tag did not engage in any FIHA-regulated activities regarding Lively. Therefore, Tag has not conflated anything as disingenuously alleged, but rather addresses the issues highlighted by the court. Tag did not engage in any FIHA-regulated activities. In a legal Hail Mary, Lively now argues that Tag should be deemed Lively's employer under FIHA, which position is directly contradicted by her own pleadings. Specifically, Lively now claims for the first time that it is undisputed that Tag meets the necessary definition of employer. However, Lively's second amended complaint alleges that her employers for FIHA purposes were only Wayfarer Studios and It Ends With Us movie. Even worse for Lively, her pleadings expressly allege that Tag is not Miss Lively's employer under FIHA or in any other context. Ouch. Oh dear. In the motion, Tag highlighted that in Reigns, the California Supreme Court held that as a necessary minimum consistent with FIHA's language and purpose, a business entity agent can bear direct FIHA liability only when it carries out FIHA-regulated activities on behalf of an employer. In her opposition papers, Lively contends that even if Rains's FIHA regulated activities limitation applied to TAG's aiding and abetting liability here, TAG would still be liable for the simple reason that the retaliatory adverse employment actions that TAG assisted are FIHA regulated. Lively mischaracterizes the court's opinion and order when she contends that the court has already held that the conduct in which TAG participated was FIHA regulated. That is blatantly incorrect. If, as Lively insists, the court had determined that TAG's conduct was regulated by FIHA, the court would not have withheld judgment. Exactly, it would not have withheld the judgment, which is what it did, because the court expressly did not determine that TAG's conduct was regulated by FIHA. So if, as Lively insists, the court had determined that TAG's conduct was regulated by FIHA, the court would not have withheld judgment with respect to whether TAG might be liable for aiding and abetting FIHA retaliation, and would not have denied TAG summary judgment without prejudice, i.e., why would Judge Lyman have allowed her to renew her motion if her, TAG, I'm thinking of Alyssa Nathan here, why would the court have allowed TAG to refile a renewed motion for summary judgment if, it already made the determination that, any activities that TAG engaged with were FIHA regulated? It did not say that. It said that TAG as an employer was FIHA regulated. It did not say that TAG was Lively's employer, though. It just meant that TAG had a minimum of 5 members of staff and carried out FIHA regulated duties, i.e., it employs staff. But at no point did it say that then gives Lively protections under FIHA, because TAG is not Lively's employer. And it's wild that she's even trying to suggest that. With respect to Smith, Lively argues that it confirms that aiding and abetting liability does not depend on an employment relationship or the performance of employment-related functions, but on knowledge and substantial assistance. While the California Court of Appeal rejected the notion therein that defendants had to be plaintiff's employer to be liable under FIHA, the court did not determine whether a third party engages in substantial assistance or encouragement to violate FIHA, where it performs no employment-related functions. Furthermore, after Smith, the California Supreme Court expressed no view of the scope of a business entity's agent's possible liability under the FIHA's aider and abetter provision. Notably, Lively does not cite a single case from any jurisdiction in which an entity was deemed to be liable or potentially liable for aiding and abetting alleged retaliation under FIHA without engaging in any employment-related activities. The cases cited by Lively involve entities that clearly engaged in employment-related activities, unlike the case before this court. In Harper, the United States District Court for the Central District of California found that plaintiff had adequately alleged a claim for aiding and abetting race discrimination under FIHA against a company that conducted background screenings on potential hires and exercised control over the threshold background screen grade needed for the employer's conditional offer of employment to the plaintiff to be confirmed. In Hooters of America, the plaintiffs were employed as servers in a Hooters restaurant jointly owned and operated by franchisor Hooters of America and co-defendants, and the Court of Appeals, where they were allegedly subject to abuse and harassment in violation of FIHA. The Court of Appeal affirmed the denial of Hooters of America's motion for summary judgment on plaintiffs' claims for aiding and abetting under FIHA, because Hooters of America failed to negate allegations it provided substantial assistance via its provision of training, policies, procedures, and administrative support designed to assist its co-employers with avoiding liability for FIHA violations. Finally, Tag does dispute Lively's allegation of aiding and abetting. Yeah, because Lively tried to say, well, Tag does not even dispute, the allegation of aiding and abetting. But to be fair, Tag were told that they could renew on specific grounds. It didn't go any further than that. So you can't just, you take an invitation to renew on specific grounds and then throw in everything else you think is relevant. That's not what you were invited to do. In the recent opinion and order and during a subsequent telephone conference, the court authorised Tag to renew its summary judgment to specifically address the issue of whether aiding and abetting liability might apply to business entity agents. Exactly, they were limited to specific topics, that's it. In turn, Tag confined its subsequent motion papers to addressing that issue identified by the court. Nevertheless, and perhaps desperate for any favourable headline, Lively highlights that Tag's renewed motion does not dispute that Tag knowingly and substantially assisted the conduct that Lively contends was actionable FIHA retaliation. In other words, according to Lively, Tag should have abused the court's leave to renew its summary judgment motion as some sort of license to argue anything that Tag desired. Exactly. That's my point. While some parties may have engaged in such conduct, Lively, Tag will not. However, for the purposes of clarity, Tag denies that it participated in any conduct that is actionable under FIHA. In addition, Lively has presented no evidence to the contrary. If Tag's renewed motions for summary judgment and for judgment on the pleadings are both denied, Tag will demonstrate at trial that Lively's claim for aiding and abetting lacks merit. Conclusion: for the foregoing reasons, as well as those set forth in Tag's initial memorandum of law, the court should grant summary judgment in Tag's favour on Lively's 7th cause of action for aiding and abetting retaliation under FIHA. Thank you very much, Mr. Fritz, for a wonderful filing, great snark, and a lot of laughs. So I hope you enjoyed that. That was incredibly good. I feel very, very positive that this motion for summary judgment could see the back of another of Lively's claims. I think it's incredibly strong. I think Lyman is inclined to grant it. I think that's why he gave Tag the roadmap to it in the first place and kind of not assisted them, but just, reminded them of the way that the California Supreme Court treats direct liability and aiding and abetting liability. So great, really happy. Let me know what you think in the comments.